Today we take up the question involving the private resolution of international disputes. Now, dispute resolution is one of the most important aspects of the law. It's what the law does, is it helps to resolve disputes. Now, we know that the law is meant to regulate relationships, regulations between members of the community and the state, or regulation between the relationships between the members themselves. And one of the ways that the law regulates relationships is to resolve disputes. That's one of the functions of the law, is to resolve disputes. Now, in fact, there are different methods for resolving disputes, and some of these methods are public, things like using the court system, and some are private, meaning using negotiation or mediation or arbitration. And in the international context, parties will often choose private resolution methods. By far, most international disputes are resolved through private resolution methods. There's a lot of advantages to it, and that's what we're going to be talking about today. So in this lecture, we're going to examine the private means of resolving disputes. Now, the first question that comes up is, how should businesses handle disputes? We know that the best way to resolve a dispute is to avoid it in the first place. And in the business context, we do that through our contracting, careful contracting, defining terms, making sure both parties have what in the law we call a meeting of the minds. So avoiding disputes is the best way to resolve them. Another method of resolving disputes in general is litigation. And this means filing a lawsuit, going to court, going perhaps to a trial, having a trial, maybe then appealing to a court, maybe then appealing to another court. That's all a process called litigation. And that's what we'll be talking about in the next lecture on the public ways of resolving disputes. Now, privatized methods, they give us an alternative means of resolving disputes. There are many different ways of resolving disputes internationally. Now, there are two issues that are always going to arise when it comes to an international business dispute. And we'll talk about these now, and we'll talk about them in the public means. But these issues are always present. And the first has to do with choice of forum. Choice of forum simply says, where is this case going to be heard? If you are involved in a dispute with a local business, well, that dispute's going to be heard right where you are. If you're involved in a dispute with someone in the same state, well, somewhere in that state, the dispute will probably be heard. In the same country, well, somewhere in the same country it would be heard. But of course, when you are looking at international considerations, this question of which court is going to hear the case is going to become vitally important. So choice of forum is the first issue that always arises in a dispute. The second one is choice of law, meaning whose law is going to apply to this dispute. Is it going to be the state of Oklahoma? Is it going to be the state of Texas? Is it going to be the country of France? Is it going to be the country of South Korea? Which law will apply to the dispute? Now, these are two key issues, and one of the benefits of using privatized means of resolving disputes is that the parties can choose these at the time of contracting before the dispute ever arises. We can decide, and we should decide, as to where any disputes will be heard and what law will apply to that dispute. Now, there are three primary ways of resolving disputes. And the first is negotiation, which you probably know. It's the idea of picking up a phone, calling them, talking it out, working between the parties to resolve the dispute. The second is what we call alternate dispute resolution, oftentimes referred to as ADR. And ADR generally refers to mediation and arbitration. And we'll be talking about each of those in just a bit. And the third is litigation, filing a lawsuit, going through a trial, maybe an appeal. That's another means, and as we'll see, that's probably certainly the most expensive, the most time consuming, and probably the least effective means of resolving disputes.